Hello students, welcome to aceacademy. Welcome to the session on current affairs. As a part of our daily news analysis, let us today discuss about the Shabarimala review case. Recently, the Supreme Court has accepted a review petition filed under Article 137 of the Constitution. This review petition was filed challenging the verdict given by the Supreme Court in 2018 September on Shabarimala issue. This issue is related to the entry of a woman in Shabarimala pilgrimage. In this context, let us understand the Shabarimala issue and also let us know what Supreme Court said in the review petition. To look into the background, we need to understand few provisions of the Constitution, especially Article 14, Article 25 and Article 26. Let me tell you about these three articles in brief. Article 25 to 28 of the Constitution deals with freedom of religion. Freedom of religion. Article 25 talks about the right to religious affairs or the right to religion. Right to religion. It says, Article 25 says, every citizen in this country has a freedom of conscience and free possession, practice and propagation of any religion. Of course, there are few exceptions. No religious practice, no religious propagation shall affect the public law and order, public morality as well as public health. So Article 25 of the Constitution confers right to religion to each and every citizen in this country. Along with Article 25, Article 26 talks about the freedom of the religious or the freedom of the religion to administer, manage and control the religious institutions owned by them. Meaning, the so particular religion groups can administer, manage and control their own religious institutions like temples, church, masjid, etc. Now, what is the take on the two things with regard to this case? Can the judiciary or can Indian judiciary interfere in the religious affairs of the citizen is the question here. When this was asked in the Supreme Court in a famous case in 1954, Shirur Mat versus Union of India, the Supreme Court came with a doctrine called Essential Religious Practice Test. According to this, the Supreme Court said the religious practices should be divided into two types: essential practices and non-essential practices. Now the Supreme Court said, if there is any issue related to the religious affairs, that issue shall undergo this test called Essential Religious Practice Test. After undergoing the test, if that issue falls under essential practice, the Supreme Court will not interfere in that issue. If that issue falls under non-essential practice, yes, Supreme Court has a complete right to review and give judgment on those issues. Now, this is Article 25 and Article 26, meaning Article 25 provides right to religion for a citizen and Article 26 provides the religious institutions to come up with the administrative rules, management and any control. Now what is Article 14? Article 14 talks about the right to equality. The right to equality. Now, let us know the issue. There is a famous temple in Kerala called Shabarimala. In that Shabarimala temple, the temple has framed certain rules where women between the age group of 10 to 50 years are not allowed, and this is because of certain biological reasons. Meaning, under Article 26 of the Constitution, the temple trust has framed certain rule not to allow women between the age group of 10 to 15 because of biological reasons. Now, when this is not allowed, a woman right to religion under Article 25 and a woman right to equality under Article 14 has been taken away. Now, when any citizen's fundamental right is taken away, that can be challenged in Supreme Court directly under Article 32. And this was challenged in Supreme Court. A 5-member judge bench is constituted, and this bench has delivered its verdict on September 28, 2018. According to this judgment, the bench with 4:1 said the women between the age group of 10 to 50 years shall be allowed to Shabarimala temple. Meaning, now the women between the age group of 10 to 50 years are allowed to Shabarimala temple. In the year 2019, Indian Young Lawyers Association has filed a review petition. Under Article 137. Now, when this review petition was filed to review its own judgment, which was given in 2018, the Supreme Court said this is a broader issue and it shall be referred to a larger bench. So, Supreme Court recently has formed a 9 judges bench. A 9 judges bench to deal with the issue. But Supreme Court also included 2 more aspects in this case. The first one being 2 more aspects in this case, and one second, yes. Yeah, the first one being women entry in mosque. The women entry in mosque is also prohibited in Islam. So this larger bench of 9 judges will also look into this issue. And the second one is Parsi women entry into fire temples. And the third one being the so-called Shabarimala case. So we are awaiting for the larger bench for its trial. The trial is happening. So we are awaiting for the larger bench to look into the issue and deliver a judgment. Keep a look on this news. This is very, very important for your prelims as well as mains. Now let us look into a practice question. And this practice question is related to the topic which we have discussed yesterday. Now let me also tell you one thing. After this topic was discussed, there was a development regarding this topic. I will also try to explain that certain development. First, let us solve this. Consider the following and choose the correct statement. Article 243K of the Indian Constitution deals with the Constitution of State Election Commission to conduct elections for municipalities. Wrong statement. The state legislature has the right to decide the tenure and conditions of the office of State Election Commissioner. This is a correct statement. Answer is B, 2 only. Why? 243K is related to conducting elections for Panchayati Raj institutions and not municipalities. For municipalities, right, Article 243. For municipalities, Article 243 ZA deals with the Constitution of State Election Commission and its conduction of elections to municipalities. Now, the second statement is correct. The state legislature has complete right to decide the tenure and conditions of the office of the State Election Commissioner. Now, we all know the government of Andhra Pradesh has decreased the tenure of the Election Commissioner from 5 years to 3 years. And this has made on the grounds of the political reasons to remove the present Election Commissioner. Now, recently the Amaravati High Court has given a verdict in favor of the Election Commissioner who was removed. The Amaravati High Court has asked the AP government to continue with the Election Commissioner who was previously appointed. The Andhra Pradesh High Court once again upheld the provisions that the constitutional superiority given to any institutions cannot be used for their political will or for their political benefits. So this is for today. I'll see you guys tomorrow with another current affairs. Thank you.